Hello and welcome to another edition of Decoding with Finsec, our internal podcast. Uh, Today we are discussing SEBI's consultation paper on settlement regulations. We have with us Mr. Sandeep Parekh, our managing partner, and my name is Anil Chaudhary. So today, hi Sandeep. A long time we've not discussed anything. So today is a good day to discuss the SEBI settlement regulations. SEBI has now come up with a consultation paper which basically the basic premise of the consultation paper is that they would like to reduce litigation, and in terms of they want to create simpler, less discretionary, easy to implement, and that is the stated objective in terms of the consultation paper. And they come up, the only thing that settlement consultation paper discusses is to how to reduce the settlement amount which is currently applicable in the current regulation. They want to reduce the settlement amount from 8 times to 4 times. I'll come to the what is 8 times or 4 times. So SEBI has studied the last 2 years of all the settlement applications which were rejected or withdrawn. And then those settlement applications went to become penalty orders. And what was the penalty amount? So assuming in a case where somebody had gone for a disclosure violation settlement, and SEBI came up with a penalty settlement amount of 40 lakhs, and the party said that I don't want to settle, I want to withdraw, and the case went back to adjudication. A penalty of 5 lakh and on average was zero. SEBI is saying that if you had gone for a settlement, you would have paid 40 lakhs in the settlement amount, and if you are taking as penalty, the penalty amount was 5 lakhs. And that is a study of 2 years only, and 2 years only involved the cases which were settlement which was applied but was withdrawn/rejected. And on this basis, SEBI as the stated goal of this paper is to reduce this 8 times to 4 times. And that is the basis of their study, and that is the entire premise of the consultation paper, is to reduce the settlement amount. However, they have not mentioned the term to make it cheap. They have said simpler, less discretionary, and easy to implement, but the only suggestion they have is to make it cheap. So they should add a line called "and cheap." So having said right, what SEBI wants to do is make it cheaper. What are the steps they are taking? We're not going to discuss all the steps. But my primary issue in terms of settlement regulations itself, as to since you were the pioneer of settlement at SEBI when you were ED Legal SEBI there, why do you think there should be such an elaborate process of settlement with a rate card given? SEC doesn't have a rate card. You have a rate card. What is the policy goal? Why do you think that SEBI or the market regulator should have a settlement policy and a regulation to that effect?
So, good to be back. And I think the sense of why we are different from the SEC has to do with public perception more than anything else. And which is why, this design is also very different from the SEC. They don't have an external committee. They don't have so many checks and balances, because I think they are a lot more trusting of the regulator, whereas, people see public servants per se, as being kind of potentially compromised. And therefore, you create all these checks and balances to reduce the chances of A, corruption, and B, any kind of look that discretionary powers are being abused. So I think that's where the rate card itself is coming from. The original plan was to keep it very simple. It was, a 1 or 2 page interpretive circular which came out. And over time, I think they kept introducing more and more kind of checks and balances. And they also kind of created what we lawyers like to popularly call a rate card, which is, if you do a violation, this is how we're going to judge you for it. And there's a base price, and all kinds of other complications which for which you need masters of physics to.
But why settlement? As in, why should there be settlement for any enforcement agency?
So I think the primary purpose of settlement is to reduce litigation. And again, I'm not going by today's data, but the data back in 2007 showed that there's a 15-year pendency of cases which were pending with SEBI. That was the highest, and then there was a pendency of several years, and Supreme Court again several years. So overall, I think India can do with a lot more settlements. Even in areas where settlement is permitted, it's very rarely successful. I think SEBI is one of the few exceptions where it's been executed well. And like I said, I think the optics have shown that the process is independent, that it's not discretionary, and it follows some kind of uh, pricing benchmark, as if you will.
So basically, you're saying that see, in terms of any administrative power, to exercise any administrative power, which is a government regulated body, say all Indian regulations want bright line tests. Do not give them too many discretion. Give them a rate card.
Yep.
Choose between X and Y, and also have such an elaborate process where settlement is more elaborate than adjudication. You first go to an internal committee, and then after internal committee, then it will go to something called an HPAC, and after HPAC, a panel of full-time members.
Yep.
It is the issue with settlement is the process it takes, the time it takes. 250 to 300 days minimum for any settlement applications to be filed, and that should be reduced and simpler. The cure is not to make it cheap. The cure is to basically remove the bureaucracy around it. And what SEBI is trying to say, if the proposition is that the caseload is very high and now you want to reduce the caseload, 15 years litigation journey, etc., then is the solution that you make it cheap, because that's all this settlement consultation paper does. Does that solve the purpose? Is that should be the stated goal of a regulator to say, okay, fine, if the stated goal is to reduce litigation, settlements are too expensive, and it is 8 times the cost, let's make it 4 times, and therefore it will be more people will go for settlement, and that is a panacea. Is that a right approach for the regulator?
So again, this is still a consultation paper, so they've not made up the mind, it seems. But I think on the first point that you raised, I think it's good to have these multiple checks and balances. I think the bureaucracy is important because, given the context of India, I think I don't think it is either necessary. I mean, they can certainly speed it up. It's not like with the bureaucracy they can't speed it up. SEBI has pretty vast treasury of their own, so they have resources to kind of throw at this. So I think the bureaucracy is okay. It can be speeded up. But on your second point of the pricing, I think this is probably coming again. It's just a complete guess. It's probably coming from the wider government push towards ease of doing business, and they've recently done it for corporate law as well. The penalties are extraordinary. For small companies, SMEs, paying tens of lakhs as penalty for late filing of documents was completely disproportionate. So they've done it there either by way of amnesty schemes or kind of reduced payments for a limited period of time, and that's probably where this is coming from. That you want to kind of make things easier. Of course, there should certainly be kind of some segregation between serious offenses and kind of more technical violations of delayed filing, etc. So I think we can come to that later. But I think broadly the principle is coming from reducing penalties and therefore kind of making it less harsh on the wider community of people who may have violated securities law.
Coming back to the point, if the goal of a regulator is first to enforce securities law, you are the only regulator in the country who takes care of the entire enforcement and of the securities law in the country. Now, if I have the data in front of me, which says the cases with SEBI show cause notice or even for 11B or adjudication order, which has been filed in past 3 years, 23, 24, 24, 25, 26. It has in fact reduced. Adjudication orders which have been filed, initiated in 23, 24, 269, 24, 25, 204, 25, 26, 135. Proposed, reduced over the years. Even for 11B, 118, 23, 24, 113, and then 51. The total number of outstanding cases is 294 adjudication, 158 pending. Hardly 450 cases SEBI has. It's that SEBI cannot even handle adjudication 450 cases, or number of cases are reducing. Then what is the rationale for SEBI to say no, I still want more cheaper settlement, more to happen? If the premise is that to regulate, to reduce the litigation burden, to have more time for taking serious actions and smaller actions should be settled. But the cases have been reducing. There is a data which shows that. And SEBI has come up with one flimsy analysis of 2 years, past 2 years, those two data where that also is very flimsy because you've already seen cases where settlements were filed but were rejected. What about 5 years? And then what about there will be different cases and different type of events? You cannot compare those to say that. What about litigation cost for everybody who's fighting a case will at least pay one similar amount of money for the as much as penalty for the litigation. So it's not 8x or 4x, it will be 2x or 4x at the most. So to that extent, do you think that there is a rationale in terms of SEBI at least to initiate this consultation? I have a problem that should a regulator with such less empirical analysis, with less such data only of 8 times, 4 times, based on 2 years of study, is that enough to reduce such drastically the settlement amounts?
So I think again, like I said, it's my guess only. It's probably coming from overall reducing the kind of burden. And it's probably coming from corporate law. The data, I agree. I think it seems to be, you need a reasonable sample, and this, the only cases which have gone into settlement and failed is actually a very, very small
And also last
small
2 years.
number last 2 years. No, so I mean they with current AI tools, they can certainly look at all the data. For instance, 2% disclosure under takeover law. What were the penalties over the past 10 years? That data can be analyzed by SEBI in minutes, not even. So I think they should have taken a more holistic data, number one. But I think the motive seems to be fine, which is that, we want to ease of doing business. At least the more technical violations should be let go. I would in fact argue in support of SEBI's, because at some point, a very large number of cases which SEBI brings actually SEBI is going to lose them because they don't have data they don't have enough facts to support their case. And the only reason they bring them today is because they know that everybody will come for settlement, and they will kind of show to the world that they've done their job. Whereas it harms people's reputations really, and we've seen so many cases where we work where innocent people have been caught up because and those innocent people are actually paid up those settlement amounts. So I think the false positives and false negatives both are a problem with SEBI processes. So I think my solution would be really be some little bit different, which is bring cases very selectively, and practically my sense is 90% of the cases today which are more procedural, late filing, which don't harm investors, should be just should end with a penalty, should end with a warning, not even a penalty. And then you're looking at 40-50 serious cases, in which case I think there's no need to really reduce the numbers like you said, but either pursue them more forcefully through consent, or kind of basically settle them at larger numbers.
To be fair to SEBI's data comes from, although they're not quoted the data, we have done some analysis using AI tools. This is data. All the data which have come to us, of course, we've gone through the annual returns also. Almost 50% of the settlement cases are rejected / withdrawn. SEBI wants, and SEC has a 90% strike rate of settlements happening. So in terms of that is where SEBI is feeling as to why the settlements are not happening. But there are a lot of other reasons for settlement not happen, but that will not get into it. There may be strategic reason. There may be reasons that there may be 15, one show cause notice may lead to 15 settlement application. And that you don't know which one is doing for what reason. So It is not but then I come to the whole issue of settlement, whether that is a panacea in terms of a regulatory objective. Because are we creating enough deterrence in terms of making it cheaper? Because the first principle of law and economics is that the cost of violation is, if the cost of violation is cheaper than the benefit that I get, then I might as well violate the law. So and also if the second point is that if law and economics says that if it is more difficult to catch an offense, when you catch that offense, you will give exemplary punishment. So if in insider trading, not all insider trading will be fine. So millions of trades happen every day. So one in, let's say, 20 got caught. So one in 20 get caught, you make them exemplary punishment so that the 19 get deterred. So as and when it's as opposed to like a traffic light violation, that there is a rate card, you don't wear a seat belt, 500 rupees you give. You cross a red light, you give 200 rupees and go on. So there are rate cards for all these things without any for small violations which is easy to be caught. So from that perspective, do you think there is enough deterrence where SEBI to say that it would reduce the where insider trading, market manipulation, siphoning of funds, everything, nothing is off the menu in new regulations, proposed regulations, and everything can be settled and at a cheaper price. So does that create enough deterrence in the regulatory market environment?
No, so I think it does. I think the bigger problem is false positive. I think I think there's so many cases where and the classic example is the very recent Supreme Court case of Shade, where SEBI said something, they found these people guilty of insider trading. SAT reversed it, saying that they were doing it for the benefit of the company, and the Supreme Court overturned SAT, upholding SEBI. So, for the same facts, if courts cannot agree on whether something is insider trading or not, to say that we have to make it exemplary, and again, this case where it was more gray. There are cases where the evidence is completely the law is so one-sided. You deemed insider, you kind of deemed to be a crook, and then you have to disprove, and it's impossible to disprove unless you have a camera on your head 24 hours. So I mean, those are the kind of laws we are dealing with. So with that, I think exemplary. I would use the word exemplary punishment only in cases which are very, very solidly proven. The Rajratnam, Rajat Gupta kind of cases, which are very rare, at least in my own experience. So I would be cautious before kind of going down that jurisprudential route that we need to have a public hanging kind of.
So that's why I think then if I come back to my last question of this today's session, that's how SEC has done it. As this SEC in terms of settlement, they have a minimum amount you have to pay irrespective of what violation you've done, and that also is inflation adjusted. It's not like a rate which has been given and every year is the same rate. B, they have three structure. One is all violations. B2 is violation which are intent based, that is fraud, etc. Third is intent based, fraud, etc. plus market wide impact. These are three violations, and there are of course minimum higher amounts for each of them. SEBI has painted everything with on the same brush. There's hardly any kind of factoring which has been done for such grave gross violations. And actually, even in the consultation paper, they have tried to make it cheaper. So now, my point is that how I see it is that like in cases like in criminal law, there is rape, murder, dacoity. Something similar in insider trading, front running, which are and like the market manipulation, siphoning of funds. These are intent-based crimes where basically it's a criminal. SEBI hardly takes any criminal action. And if you don't take criminal action and you make it a civil offense, it is a rate card. So I'll tell you, give an example. A client came to me and told me, there's a disclosure to be required. I don't want to disclose. If I disclose today, my competitor will get to know and my deal will not happen. So I don't want to disclose. They said, okay, fine. The client said, okay, fine. If I settle, how much will be the amount? Okay, 10 lakhs, 20 lakhs you'll pay. Okay, fine. I will not pay the 20. I will pay the settlement of 20 lakhs. There's no point filing them. Anyway, they'll settle. So if that, when you're skewing your nature in terms of filing, making the settlement cheaper and everything is open door, and basically SEBI is saying for every show cause notice, I'll first tell you settlement notice with a rate card. This is your rate card, you pay and get out of it. So what is the point of SEBI enforcement agency? They should call themselves as a settlement agency. After doing so much investigation, you have created so much algorithm, infrastructure, technology to detect those crimes, and then to leave them at such low prices or everything under the menu which can be settled. Is that the panacea that regulatory architecture of this country should move towards?
No, so it's an open question. I don't want to answer it, but I think the new process itself, I'm not very happy with respect to. So before show cause notice, kind of saying this is the number you pay, which to me is somewhat extreme, because you don't even know the perimeter of what you're charging somebody with, and you're saying pay X amount. It's like it's a bit like you went to the ceiling and here's your traffic challan. We're not sending you photos. We have no evidence, but if you pay this, we're not going to send you a challan. So I think that's a very dangerous path jurisprudentially. Yeah, I mean there's certain kind of multiple views possible on the overall jurisprudence of whether to have settlement, how to address it, how to calculate it, and but my sense is I think it's fair simply for the reason there's so many false positives which are coming up in the system that people not non-guilty people want to settle today because they don't want the reasonably high probability that they'll be found guilty of something which they've not done.
Basically, it's a regulatory arbitrage now. It is a regulatory arbitrage way to say that we do not trust the regulators' process, and it's better for me to go get out and settle. And if it becomes cheaper, it actually helps those people. But then the flip side to it, it actually gives wrong incentive to the crooks.
To the crooks, for sure.
To crooks, they will use the system to make advantage. They know the rate card now.
Yeah.
Once they know the rate card, the disincentive is gone in terms.
No, it's a fair criticism, but like I said, there's a flip side to it as well. So,
okay, I think that's good for today. I think if we'll have one more session in terms of what all changes we have done. Oh, one more change I just want to highlight because this is relevant for this is the last bit they have saying that they have tied the amount of settlement is to the minimum penalty which is prescribed under the SEBI Act. Now, SEBI Act came in 1992, and of course there are some revisions in terms of the minimum amount, but the minimum amount is not increased too much. So let's say 1 lakh is the minimum amount of penalty for a fraud, and going up to 25 crores. So the fraud will be pegged at 1 lakh, and then multipliers will be added for how much he can eat back. We will do the next session. We'll give you a study as to what all was the minimum settlement amount in the previous regime as opposed to the new regime would be, and even the frauds and etc. will become so low that it is actually again becoming a rate card. So I think that is what I wanted to highlight also as to how they have linked it to the minimum penalty amount as opposed to this current existing regulation where they have applied their mind. They have said the 15 lakh for fraud minimum, disclosure like 2 lakh minimum. So they have applied their mind to understand what should be more and what should be less. Now they have just gone back to the minimum amount, which is actually does not give the correct picture in terms of what is the gravity of the offense.
Look forward to that.
Okay. Thank you for today. Thanks a lot.